From Deloitte Tax and Legal Japan, welcome to the Japan Perspective. This is a podcast where we speak to specialists from across Deloitte to discuss the latest business issues impacting foreign multinational companies in Japan. I'm your host, Joanna Hazel. On today's episode, we will be discussing Pillar 2. Japan recently implemented Pillar 2, so we'll be discussing how its implementation affects foreign multinational companies here in Japan. Joining us today is Brian Douglas. Brian is a managing director with the Business Tax Services team here in Tokyo. Thanks for joining us today, Brian.
Yeah, great to be here.
Thank you. All right, so just so our listeners are all on the same page, I want to first ask you, what exactly is Pillar 2 and where does Japan currently sit with its implementation?
Well, Pillar 2 is a global minimum tax that's going to be imposed on large multinational corporations, and it's designed to ensure that wherever a multinational organization generates income, that income is going to be taxed at a minimum rate of 15%. And it does this through four different mechanisms to ensure compliance. And the main mechanism is what we call the income inclusion rule. And this functions like a top-up tax. So you can imagine a global organization that may have a subsidiary in one jurisdiction that generates income that's subject to a 10% tax rate. Well, the income inclusion rule is going to impose an additional tax on the parent company for the difference between the 10% actually paid by the subsidiary and what would have been paid if it was subject to a 15% tax. There are a couple other mechanisms that will apply within the Pillar 2 regime. One of those is a subject to tax rule. And this is really aimed at developing countries, and it allows them to claw back some of the taxing rights that they may have given up under their respective tax treaties, where the counterparty taxes an item of income at a rate of less than 9%. There's also something called the Qualified Domestic Minimum Top-Up Tax, which functions similar to an income inclusion rule, except at the domestic level. So in that example I gave before, instead of the parent entity's jurisdiction imposing additional tax on the parent entity, it's going to be the jurisdiction of that subsidiary that imposes an additional tax on that subsidiary to ensure that the income is subject to a 15% tax. And the final mechanism within the Pillar 2 rules is something called the undertaxed profits rule. And this would apply after we apply all those other mechanisms that I just mentioned. And this functions as a kind of a denial of a deduction on intercompany payments when those payments are made to a jurisdiction that is subject to a rate of less than 15% tax. And now, where is Japan with respect to all of these different rules? Well, earlier this year, Japan has actually enacted the income inclusion rule into its domestic tax law, and this will come into effect for tax years beginning on or after the 1st of April, 2024. And while the other mechanisms have not been enacted yet in Japan, we do expect them to be enacted in some form in the near future.
Got it. Thank you. So you mentioned that the income inclusion rule, or IRR, as we can abbreviate, is generally imposed at the ultimate parent level. So what impact, if any, would the IIR, which Japan has now implemented, have on a Japanese subsidiary of a foreign multinational company?
I think for the vast majority of foreign multinational companies, the impact is going to be minimal. In fact, they may be limited to simply filing a notification with the Japanese tax office. However, there are some multinational companies that have very specific fact patterns where the Japanese constituent entity itself may be required to calculate a top-up tax. And the first thing to note with respect to these fact patterns is that the Japanese entity itself must have its own subsidiaries. Otherwise, there's no income upon which to calculate the top-up tax. And there's a couple scenarios in where this could apply. One is where the Japanese entity is considered a partially owned parent entity. And that means while it's part of a multinational group, at least 20% of its shares are held by someone outside of that group. The other way this might apply is where none of the entities that sit above the Japanese entity within the multinational group are applying, or the jurisdiction in which they sit apply an income inclusion rule. And in that case, the Japan entity itself may need to apply the income inclusion rule with respect to its own subsidiaries.
Got it. That makes a lot of sense. So my next question is, while some of these other mechanisms might not necessarily be implemented yet, are there any other elements of the other mechanisms, such as the subject to tax rule or the qualified domestic minimum top-up tax or under tax profits rule, that a Japanese subsidiary or branch office should be thinking about?
As I think many of our listeners know, Japan is a high tax jurisdiction, typically, with an effective tax rate between 30 and 34%. Now, this rate is much higher than the 9% mentioned under the subject to tax rule, much higher than the 15% under the qualified domestic minimum top-up tax rule. So unlikely that these will have a significant impact in Japan. So there's really not much for companies to consider at the moment with respect to those mechanisms. However, with the under tax profits rule, we might see more of an impact because we're not looking at the Japan effective tax rate, but the effective tax rate of the counterparty. And so this could come into play once Japan implements this particular rule. So companies might want to start looking at some of their intercompany transactions and see if Japan is making payments to a jurisdiction that might be considered a low tax jurisdiction and might be captured by this undertaxed profits rule.
Okay, so with that in mind, are there any actions that Japanese subsidiaries should be doing now?
So I think that depends on the specific situation. So if we look at multinational corporations where the Japanese entity is kind of on the bottom tier of the organization chart, there's no subsidiaries, or it's been determined that the income inclusion rule is going to apply at an upper tier level and not at the Japan constituent entity level. Well, I think the first action for those companies to take is to get connected with the global tax departments, with the tax department in the ultimate parent entity jurisdiction or in the regional headquarters, and just understand what's going on from a global perspective and how Japan can support the efforts of the organization as a whole, whether it's providing information or whatnot. In addition, the Japan entity needs to put on its calendar that compliance obligation that I mentioned. It will have to file a notification at some point. So those are the two actions I would say for those types of multinational groups. Now, for the multinational group where the income inclusion rule is going to apply at the Japanese constituent entity level, again, I think the first thing that companies should do is get in contact again with the headquarters, with the regional headquarters of ultimate parent entity jurisdiction, and again understand what's being done from a global perspective, because Pillar 2 is something that impacts the organization as a whole. And even though the income inclusion rule may apply at the Japanese level, there may be another entity within the organization that's actually responsible for collecting all the information, calculating the top-up tax for the group as a whole. So that's the first step. If it's determined that the Japan entity is responsible for doing all of that, well, then I think the next step is to get in touch with your tax advisor and start really developing a plan, which would include making sure those responsible for Japan tax understand the rules, the Japanese rules with respect to income inclusion, understand how it's calculated, understand what kind of information will be needed and how that information is collected, and really understand whether any of the transition rules or some of the safe harbor rules will apply to them, and develop a timeline from now until that top-up tax is actually needed, required to be paid to the Japanese authorities.
Right. Well, thank you so much for all of that information. Hopefully our listeners can find that helpful and have a little bit clearer of a path forward when it comes to the implementation of Pillar 2. Thanks so much for your time today, Brian.
Yeah, thanks, Joanna.